Joining us right now is Joe DiGenova. He's our legal analyst. He joins us every Monday. And this, the eve before Christmas Eve, gives us an opportunity to wish you and your family a very Merry Christmas, Joe DiGenova.
And the same to you. I'm reporting live from Burlington, Vermont, on the shores of Lake Champlain.
And are you looking at a snow-filled landscape there? Is it a nice
Indeed,
white Christmas?
It is truly magnificent up here with the kids and grandkids with Victoria, and we're having a wonderful time.
Well, that sounds great. Now, no, don't get too laid back, but we count on you to bring some heat every Monday morning, Joe DiGenova.
All right, let's melt some snow.
Let's start with last week's hearing on the NSA. This was a pretty remarkable hearing, a ruling specifically from this federal judge, Richard Leon, here in Washington, but also another ruling in California. Am I looking at this right?
Yes, actually, one of the lawsuits, remember back in 2006 when the New York Times ran the article revealing the metadata collection and all of that?
Right.
A bunch of lawsuits were filed. This is one of the ones that has survived, and the judge ruled last week and demanded that the government produce information as to why he should not rule it unconstitutional. And in the course of doing that, the government filed a bunch of motions last week in which they said that state secrets would be revealed and that therefore he should not rule. Now, this lawsuit has come a long way because originally the government argued that these people couldn't prove that they had been listened to. Well, of course, after Edward Snowden, everybody knows that we have all had our telephone numbers collected and the metadata around it, even if our calls haven't been listened to. So these people clearly have standing to sue, and now the government is arguing that even if they do have the right to sue, the court shouldn't hear any of the evidence because it is too secret, too important, and too indispensable to our national security. And he is relying, or the government is relying, on an affidavit from James Clapper, the Director of National Intelligence, whose credibility at this point is somewhere below that of President Obama's.
Well, Joe, what is the indication of some kind of harm that these people were actually harmed by the federal government?
Well, in constitutional terms, the collection of your data, and this is ultimately going to be decided by the Supreme Court. The real issue here is whether or not the collection of all of this metadata, in other words, all of these phone numbers, all of the numbers to whom they're going, when they occurred, where they occurred, all of that is constitutionally protected. The government has been relying for all of these last few years on a single ruling from the United States Supreme Court in 1979 called Smith versus Maryland, in which they ruled that you have no privacy interest in the telephone numbers that you dial.
Yeah.
And of course, the interesting thing about that case is that involved a specific defendant. The police had him under investigation already for a specific crime, and they were tracing his calls. This is entirely different from the situation we have now. I actually think that Judge Leon ruled correctly the other day that the metadata collection is unconstitutional, probably. The difference is this is easily fixable. We do not have general warrants in the United States under our Constitution. You have to have a specific warrant for a specific person about a specific crime and a specific thing. All of this requires is that the metadata that's being collected not be collected by the government. It can be collected by the telephone companies and stored, which they used to do anyway, but they stopped doing it because it's so expensive because there's so much data. This can be solved by the United States government simply paying the telephone companies to save the data.
Joe DiGenova, you mentioned James Clapper and say that he has no credibility. Of course, that stems from his testimony before Senator Ron Wyden, Democrat of Oregon, when he said, no, we're not storing people's information there at the NSA. We're not collecting data of any type on people's phone calls. Of course, that was proven to be false. And I really want you to comment on this. I don't know if you saw it or not. Last night on 60 Minutes, your friend Susan Rice, she's now the National Security Advisor to the President, when confronted by Leslie Stahl on this, listen to how Susan Rice characterizes what James Clapper said there.
Officials in the intelligence community have actually been untruthful, both to the American public in hearings in Congress and to the FISA court.
There have been cases where they have inadvertently made false representations, and they themselves have discovered it and corrected it.
Joe DiGenova, Susan Rice, you know her inadvertent false representations about Benghazi. How do you like that artful turn of phrase?
Well, I think she shows herself and continues to be unprepared for public service, notwithstanding her multimillionaire status. The bottom line is Susan Rice is an apparatchik who has been sent out by the administration repeatedly to lie on behalf of the administration. And as you well know, and the president has proved, and that's why his numbers are so low, the president and its administration has used lying as a tool of public policy, and it has finally caught up with him. That performance last night by Susan Wright demonstrates conclusively why she could not have ever been confirmed for Secretary of State, and why she was given this little prize of being National Security Advisor. This is really pretty pathetic stuff when an administration has to rely on a senior official to be so mendacious in order to explain its policies. It shows you how low Obama's presidency has sunk. But that is where he is. That's the reason he's in such bad shape, because it's so easy for them to lie that now the American people expect it, and they've decided they really don't like it.
Hey, Joe, it looks like one of the big landmark cases that is coming down the pike is with respect to Obamacare and religious freedom. And as you know, there are several cases pending. Where do you think this all turns out? Because this could have huge implications for, as I said, religious freedom in this country, and whether it's still a principle we stand by.
Absolutely. Well, I think these cases have a pretty good chance of succeeding. The swing vote will be Kennedy, because the 4 and 4, the liberals and the conservatives, are already lined up on this one. Roberts.
Now, which case are you talking about? Is this the?
This is the one with the little company, the Hobby
Lobby. Okay, right.
Hobby Lobby. Yeah. Right. I think basically that's probably a winner. That the court will rule that you cannot impose this type of restriction on a company. You may be able to require them to provide insurance. Apparently, the Supreme Court says you can because it's a tax. In Judge Roberts' ignominiously creative use of the tax function in the Constitution. But I think probably the court is going to strike this down as an interference with the free exercise clause of the Constitution.
But is there then a House of Cards effect there?
No. Actually, I think what happens is the House of Cards effect is going to come separate, and it's not going to be. It'll come in the issues of whether or not the president had the right to waive the dates and things and all these waivers that he granted people, and whether or not this creates an unconstitutional equal protection problem for people who were not granted waivers. But theoretically, I think the statute will survive, but it's going to collapse in all likelihood from its own weight and from the revulsion of the American people.
I want to ask you, though.
They thought this was going to be free stuff. Well, guess what? It's very expensive stuff.
Well, and Joe, that's an interesting thing, because it's not often that a year and a half later the Supreme Court has a chance for a do-over. The makeup of the Supreme Court is the exact same. Is there any chance, after seeing how this is rolled out and seeing how the administration continues to maintain that the individual mandate is not a tax, could Justice Roberts take a second look at this and maybe to have a change of heart?
Reconsider?
He would have to admit in a very embarrassing way that he was wrong. And of course, Justice Roberts.
Was he? Was he wrong?
Oh, he was terribly wrong.
Right.
I mean, this is one of the worst Supreme Court decisions ever rendered, and his creative use of the president said it wasn't a tax. The Congress said it wasn't a tax. Justice Roberts said it was a tax. It was one of the worst cases of judicial legislating in the history of Supreme Court opinion writing. It was abysmal. He lost status. And here's the interesting part of this. There he sits every year at the State of the Union address listening to attacks on the Supreme Court, started in 2010 by the President of the United States.
Over Citizens United. Yeah.
Attacking this court and sitting there like a goofball, taking it instead of not showing up, which is what he should do. None of the justices should go to the State of the Union after what the President of the United States did to the Supreme Court. He demeaned them purposely. He created an assault on Roberts before the decision in Obamacare, and they threatened him. They said he would never strike it down, never. And you know what? He bought into it. He caved.
All right.
It was one of the most abysmal things I've ever seen.
Joe DiGenova, we got to leave it at that. I'm glad that Currier and Ives setting up there in Vermont has not dulled your very sharp criticism of the Supreme Court and the administration. Merry Christmas, sir.
Merry Christmas.
And a Merry Christmas.